Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others, aspiring to be them, can follow in their footsteps. Here's your host, Jacob Wells.
All right, welcome to Latte with the Lawyer. I'm your host, Jacob Wells, and today I'm really excited because we have a great episode for you. We're going to be talking with Josh Curry, who's a partner and vice chair of the intellectual property and technology practice at Lewis-Brisboy. Here's our guest, Josh Curry. Welcome to the show.
Thanks, Jacob. Thanks for having me. Glad to be here.
And thanks so much for spending some of your time with us today. I really appreciate it. And before we get into any of the law stuff, because the show's called Latte with the Lawyer, I gotta ask you, what's your favorite morning drink of choice? Like, what gets you fired up in the morning for your busy day ahead?
Well, normally two things. So I'm a big exercise person. So when I can get up early enough to make that happen, I do that. And then I'm just a regular cup of coffee guy. I mean, I like a latte, mainly like what's called a misto. I still like a little bit of steamed milk, basically. But we got a Keurig at home, and that thing pumps up coffee all day. So it's just a regular coffee pod.
Love it. And it's interesting because I remember the job that I had before this. Some of the most successful wealthy people at the top of their game would just pop a Keurig pod in. Creamer, just simple, like no frills coffee, and just go to work. So I appreciate that. So before we get into the episode, can you give us a bit of an overview of who you are and what you do?
Sure, be happy to. So as you said, my name is Josh Curry. I'm a patent and IP litigation lawyer at Lewis-Brisboy. For the past year or so, I've been a vice chair of our group. Most of my practice focuses on patent litigation in federal court. I also handle other types of IP litigation, so trade secret, copyright, trademark, and occasionally I handle state court business disputes or technology disputes. There's normally some sort of technology or science type angle to it. I have a physics degree, undergrad, and then in law school focused on intellectual property. So that's sort of a brief overview of what I do, and it's a typical litigation practice, so it'll be cases around the country, patent cases. They tend not to be filed necessarily in Atlanta. There have been a few that I've had here, but a lot in Delaware, some in Texas, some in California. And it's litigation from the beginning of the case through to trial, through to appeal. And I handle all different types of matters at every stage of the case.
Cool. So you said that you had a physics degree undergrad, and that's actually something that I wanted to go into because I think it's interesting to look at lawyers and their background, and something that is a little bit different that kind of makes you stick out. So take me all the way back to your undergrad and studying physics, and then also explain to me how you think that experience has kind of helped you stand out as a lawyer.
Sure. So so in high school, I knew I wanted to do something in science. I really enjoyed science and physics and math. And so when I got to college, I started down the physics track at FSU. And the beginning of a physics curriculum is pretty standard stuff. You're learning Newtonian physics basically, and then the math gets pretty intense. Right. You actually end up getting a minor in math. So as that coursework was going on, my parents are in the military and they live overseas. So I either had to go home during the summer or stay at school during the summer. And so a lot of times I elected to stay at school. They don't teach physics in the summer. So I had to find something else to do. So I also like political science and debate and politics. So I did that during the summer. And as the kind of time went on, I said, I really enjoy the science, but I also really enjoy the social part of political science and more of the sort of people-based parts of it. So IP law was a way for me to try to marry those two things together. And you don't have to have an IP degree, you don't have to have a science degree to be an IP lawyer. Some of the very best IP lawyers I know have history and English degrees. They're just smart people. They're willing to read. So I think the main thing that physics did for me is gave me a good understanding of any type of science or technology and a good way to approach it. and a lack of fear about it. Like a lot of things that will scare most people from a science or technology point of view, I really enjoy and can really get into. And that's really what I found to be a differentiating factor with IP lawyers. If you can find a way not to be scared of the technology or worried that you don't understand it or embarrassed that you have to ask basic questions about it, you're going to do a lot better. And having some background in a science like physics, a broad science, helps you to be better equipped to ask the right questions and to get on the right track fast. But at the beginning of a case, I read tons about the technology if I've never done it before and come up to speed and get educated about it. And I am not shy about asking our expert stupid questions at the beginning, because you really need to know what you're doing. And that's what I think the science degree has done for me. Some of my colleagues also have science degrees. It's pretty common in the IP field, and it's actually required to be a registered patent attorney. And I'm also a registered patent attorney.
So having that physics background doesn't necessarily make you, like you said, like an expert. Like when certain patent cases come your way, you still have to ask questions, and the science might be new to you, right? It's not necessarily something that you have a leg up on because of the background.
No, absolutely. I mean, the only place I really have a leg up is if it is science or chemistry that I've dealt with before. So when I used to do pharma cases, some of the formulation patents would be pretty similar from patent to patent, and some of the problems they were solving would be at least in the same area, so you kind of knew what you were doing. As I got more into computer related technologies, I also have I grew up using computers when it was AOL and dial-up internet and all of this stuff that was where you had to know more about what you were doing. You couldn't just point and click. So having the knowledge and the background is really helpful, but you're still going to have to read and understand, because the patent, like let's just take a communications patent, it might be on an encryption technology, and it might be something as simple to a user as two-factor authentication. But then how does that work technically? And you still need to understand how it works. And so unless you happen to have worked on that particular tech before or have a lot of familiarity with it, even if you've used it before, you're still going to have to read the patent, read the specification, read some of the prior art to really understand what you're looking at and understand what the improvement is. Because most patents don't protect broad fields. They protect small pieces of improvement. Sometimes those pieces of improvement are critical and have to be used in a product, so they do block people, but it's that small piece of improvement normally that the patent is aimed at. And it typically sits in a wider environment, and you're not going to, even if you know the wider environment, you're not going to know small improvement right off the top of your head.
Right. So can you walk me through an example of a case where you're evaluating technology and a patent, something that you look back on as being one of the more exciting cases that you were part of?
Sure. So there have been several. Some of the ones that might be a little more interesting to folks because they're probably familiar with it are app cases. So mobile banking has become ubiquitous. Pretty much no one goes to their bank anymore. You do everything on your phone, including remote deposit. So I was involved in one of the early mobile banking cases. It's called Maxim Integrated Products. And they basically had a key fob type invention that they patented. But when you think about the way that a mobile phone works and mobile banking works, the key fob is pretty similar to an app on a phone and all the technology that goes into it, the processor, the encryption, a program, a series of steps. So they tried to read that patent on banking apps. And so I got into that. I represented a very large financial services company and several banks. And that was a really interesting case because it was against a guy named Matt Powers, a very well-known plaintiff's patent lawyer that has a very good reputation and is a hard litigator to be up against. And we had, 27 odd defendants in a multi-district litigation.
Wow.
So that was a fun case to get into, really understand what the technology was, how our technology at my 3 or 4 bank clients differed from the technology of the other defendant, some of whom were mobile retailers, and to sort of keep everybody on the same page. And I was at a stage of my career when that case was going on where I was really down in all of the weeds, technical weeds, legal weeds, and really figuring out the case. So that was a more exciting case about something that's easier to understand for folks. And then to give you one more that's in a different area. So after I came to Lewis-Brisboy, before I was vice chair of the group, but while I was a partner, had been a partner for a few years, we had a case to do with smartphone protective cases. So the little plastic case that goes around your phone. We had a design patent case for a prominent maker of phone cases. And we were fighting against someone who had basically knocked off our case. They took our plastic case, took it to China or Asia and copied it exactly, and just infringed the crap out of our design patents. And it was a hard case because they didn't have very good defenses. So they were fighting back against us constantly. And the judge actually made a bad decision in that case and said that our design patents were not valid. He invalidated them at summary judgment, which is really rare and very hard to do. So I handled the appeal of that case and got a precedential decision out of the Federal Circuit reversing the trial court decision. So that was that's the kind of gamut that my practice runs. Some days I'm buried in numbers and math and how does the processor work inside of a phone and how does it work with this application? And then I'm at the very far end of the spectrum later in the day saying, what does this case aesthetically look like? Is it substantially similar in the eye of an ordinary observer to these prior art phone cases? And what's our best way of explaining to judges in their 70s at the Federal Circuit why we need to not invalidate this patent? It just appears to be a patent on a phone case. What's the big deal? And it was a big deal from a decision-making point of view, and the court understood that. And so, but that's the gamut that my practice runs. And I could pick technologies in between. I've done everything from consumer products to drugs to other types of software to disputes that are really more about the business aspect of it than the technology aspect of it. So it's a pretty interesting practice.
Yeah, I think you have like a broad range of experience across a bunch of different technologies because of the work that you've done. I guess I'm just curious, with as far as is concerned with technology in the legal industry, where do you think that's headed in the future? How do you think your business is going to change?
So you mean things like document review and AI and automation and practice management tools?
Yep.
Well, I mean, the pandemic's a good example. There are a lot of lawyers that didn't think we could practice remotely all the time. And boy, were they wrong. You can run your law practice out of your house. I used to be more of a paper guy. I've always been really good with computers and really good at digital. But when it came time to write a complicated brief, I'd have someone print out all the cases and make me binders. And when it came time to do a big deposition, I'd do the same thing. I'd have 2 boxes of exhibits or more, all marked up and flagged. I figured out how to do all that from a technology point of view. I use an iPad, I use my computer, I use a lot of PDF markup. I think that technology will accelerate law practice and probably it'll make it harder for junior lawyers, because the tasks that junior lawyers used to do, like document review and research and other things, the technology has made it a lot easier for senior lawyers to either find contractors to do that or temporary employees or offload it to someone else. So it's hard to get the right training. And one of the things that's really challenging in law is that as the technology makes it easier for older lawyers to do more with less, there's less opportunity for younger lawyers to get into it. And you have to be that much better as a younger lawyer. You don't only have to understand what you're looking at, how to deal with your partners that are older than you and your colleagues that are your same age, but deal with outside vendors and deal with the client. Everybody's coming at it from a slightly different point of view. So it's made it harder. Is it going to replace younger lawyers? No way. Is it perfect? Absolutely not. I mean, some of the document review technology, they say you can review all this stuff with AI and predictive coding. It works sort of, but it's not quite there. It still makes mistakes that a human reviewer who understands the context can figure out pretty readily. And that's where you add a lot of value as a lawyer, whether you're an old lawyer or a young lawyer. That's what you're really doing. You help to put a lot of this in the right context and in the right framing.
So do you have any advice for a young lawyer who, is not going to be replaced, but it's definitely more challenging for them? How do they diversify themselves and have that leg up in this constantly technologically changing world?
That's a good question. I mean, I think they need to dive into the technology and not be scared of it. So they need to be, one of the things that's always good for younger folks to do is to be conversant of the technology that older people don't get. And you can take any of these things and move it along the spectrum. So if you go way back to the dark ages when we were still sending letters to each other and nobody was using email, you learning email would help give you a leg up. fast forward to now, if you really understand how this predictive coding and discovery stuff works, and you can do a good job on it and effectively manage a team of other lawyers, if you're going to be at a big firm, that'll give you a leg up versus the other associates you're working with on the technology side. But more generally, it's just nuts and bolts. Make sure you're a good writer, make sure you're a good thinker, be curious. Some of the worst things that junior people do is they don't ask questions. So if you don't know, you might look stupid, but be okay not knowing the answer. Ask. I'd rather find out right now while you're sitting in my office getting this assignment that you don't know what you're doing and give you some guidance than have you turn in a brief that's not even in the ballpark. Right. So some of it's just nuts and bolts of learning. And I do think finding a mentor or several mentors at different levels can be really helpful, but it's all personal. You really got to, as a lawyer, you got to develop your own practice, your own experience, the things that you're interested in. Stuff that works for other people might not work for you. Maybe it works great, but maybe it doesn't. And no matter what, you should be trying to fit it custom to you.
Great. Well, thank you so much for spending some of your time with us today, Josh. I think that the young aspiring lawyers are going to find this really inspiring, because I think that this is an interesting field and is ever changing. Is there a way that they could get in contact with you or find out more about you and what you do if they're inspired by this conversation?
Sure. Yeah. I mean, the easiest way is to look at my firm bio on Lewis-Brisboy.com. If you just Google Josh Curry, Curry, you can find me. It's a good field to get into. IP is a difficult area of law because the law is complicated and the science and technology is complicated, but it's growing pretty rapidly. And there are good programs at schools. So if lawyers want to get into this area, they should study it in school, because it's a hard practice to pick up once you've been out for a little while. For folks that are trying to get into it, studying and basically taking courses or CLEs can sort of get you into the area. And then it's just practice learning and understanding. It is a really exciting field, but I've heard on some of your other interviews, like, it seems like a lot of law is exciting and flashy and interesting. There are a lot of mundane parts to it too. And one other piece of advice, I think, no matter your age, you can't show up at the hearing and argue the case without putting the work in. It just doesn't work that way. So the hour you spent in court, you spent 50 hours getting ready for that, right. And that's the stuff that they sort of 80s movie montage past, I guess, including in your head, it's like that happens in 30 seconds. No, it doesn't. It happens over the course of 2 weeks. So that's all important too. And that's why I said nuts and bolts earlier. That's a good thing to be okay with doing. It sort of seems silly to say, but when we were doing hours and hours of document review as a young lawyer, we learned everything about the case. And if you could remember that stuff and had a good memory and took good notes, you were invaluable later, because the senior partner would say, what are we going to do with XYZ issue at this hearing? And you can say, well, what about these documents? Because you saw them and you remembered them. So that adds a lot of value. And that's another piece. I like to think about context. So that's you as a lawyer taking a junior lawyer on the team, taking a piece of the case and putting it in the right context from a senior lawyer on the team, who can then take that and present it to the court in a way that's valuable. So you didn't get to stand up in court, but no one would have been able to if you hadn't done the work you did.
Right. I think that's really key across any industry, is adding value. I think that's something that's often overlooked. But yeah, I think it's a really interesting field. I think, and I appreciate you touching on the mundane aspects, because I don't think people really bring that up too much. And you only see the glitz and the glamour, so to speak. So you got to be able to get down and do those mundane things. But I think, like you said, there's an opportunity there for you to find something that you could present to the partner to show value, and then that could accelerate your career.
Another way to think about that same thing is like sports. You practice a bunch, and then you play one game a week, depending on the sport you're in, and the game is the glamour part, but all the practice that went into it is super important too. Right. And clients appreciate that, because these cases last years, and they know you're working your tail off on it. And then it sounds like a long brief, but 30 pages is not very much space when you've got hundreds of thousands or millions of pages of other stuff. But that's your job, condense it.
Right. And I think also with the mundane aspects, they should be able to find that interesting somewhat, right? If you're not finding the, looking through the case files interesting, then there's an issue there.
There is, I can see why you might get discouraged on, week number 12 of 10 hours a day of document review and like clicking a button on your computer. Yeah. But it doesn't last forever, and it seems weird to say that the excitement of doing expert depositions or more complicated depositions or hearing is still there for me, but I've done enough of them now that it's not as exhilarating,
Yeah.
So clicking a button for 10 hours a day for weeks, like I said, is very uninteresting, but sometimes presenting or asking the same set of questions in another deposition, sure, it's different information, but it's the same, going through the same stuff, can drag too. So you got to find ways to keep that interesting. And the cool thing about being in law, and especially IP law, is it changes and it develops, and the case moves on. There are different stages to it. So there's plenty of different stuff to do. So if you get bored easily, try to understand that you're getting good at something. You'll be better at it later. Some of that will move faster, and there are other things to do. But don't space out and just not do it, because it's like, I mean, this is a silly thing to say, I guess, but some of the math teachers I used to have, they'd say, yeah, you only got to do like 1,000 of these problems, and then you'll get it. And you're like, oh my God, 1,000 of these, that's a lot of problems. How am I ever going to do that? But they're right. You do enough of it, you understand enough of it, and then you can look at something or even just hear a little bit about it and give the client the advice that they were looking for. And that is really valuable, because the client's not in it to be in a lawsuit. They got a business to run. They're trying to get out of the lawsuit, or they're trying to do something to their competitor. And you're a tool to try to make that happen. And so when you forget that and you focus on how can I lawyer this instead of how can I solve this problem, you often don't end up where you want to be. But you can't figure out how to solve the problem unless you've done 1,000 of them. And sometimes that means sitting there doing document review forever as a junior lawyer.
Right. Well, I'd love to continue talking more, but we got to wrap it up. I really appreciate your time. This has been Jacob Wells for Latte with the Lawyer. I want to thank Josh Curry of Lewis-Brisboy for joining us today. And thanks to our sponsor, EmotionTrac, without a K, that uses artificial intelligence and mobile app audiences to economically and quickly gather focus group research and data for trials and mediation. Thanks so much, Josh.
Thank you.
Have a great day.